What's up, everybody? This is Attorney Dan Wynn here, and I want to share a little bit more with you on trademarks and the timeline for an intent to use or 1B application. So the process is, for the most part, the same, but there's a little bit differences that everyone should need to know. Again, you don't have to be selling or in business yet with your particular name that you want to trademark. The law says that if you have a bona fide intent to use a name, then you can apply for a trademark. And I highly recommend my clients who are in that position to apply for the trademark. Why? Because it kind of locks out the competitors for getting the mark. You probably heard me tell the story before. I had a client that they thought of a name, they sat on it. When they finally launched their business, put lots of money into launching and media days and grand openings. They try to get the trademark after the fact. Sorry, they couldn't get it. And so they are, they may have to rebrand. We're still trying to figure that out, but it's kind of an unfortunate situation. But they had thought of the name a long time ago, but they kind of sat on the laurels and lost it to somebody else. And so I always advocate, once you have a bona fide intent, let's get the application in, and so you kind of lock your place in line, and you don't lose it to your competitor. So I already talked about this, the application and the review and the opposition beforehand and the office action, right? But let me go to here. Once you get the notice of allowance, so from the notice of allowance, you have up to 2.5 years to file a statement of use. And statement of use is, hey, I'm in business right now, or I'm selling these goods and services. So one of the things about trademark law is that they're not going to give it to you. It's not like domain names. You can't buy it and hoard it. You actually have to be doing business underneath the name. And so one of the things they require you to do is show proof that you are doing business, selling these goods and services underneath this name. And so, you've watched one of my other videos, some of the specimens, like if you sell water bottles, there's a name of the company on the water bottle, or if you're in services business, like financial services, you have a brochure with the company name on it. And so things that that show that you are conducting business underneath the name. And it's a little bit different for each type of goods and services. Software, if it's downloadable, then you show the download screen. E-commerce, you show the website. So the trademark office got a little bit of different rules for each type of goods or services. But once you are issued the notice allowance, you have 2.5 years to prove that you are selling under that name, and you are granted a 6 months extension. So in 6 months, you're not doing it and you need more time, then you file a request for extension. Now, 6 months, if you're in business, all right, let's file a statement of use. If not, we're gonna file a request for extension. All right, so that can go on up to 2.5 years from the notice of allowance. And so, that should be enough time for most people to get out to the market. Okay. Again, the trademark office still has to approve your specimen. If you watch one of my other videos, the trademark office is really cracking down on specimens, digital specimens, especially. So like brochures, especially, what I do for my clients is, oftentimes they'll send me the digital file, but I'll ask them, hey, print it out and then hold it, right? Hold it or put it on a desk. And so it looks like a physical item, and then take a picture of that physical item. And so the trademark office is really cracking down on specimen fraud. And so we try to do our best to put our clients in the best position to make sure that they're not getting rejected by the trademark office. And so the trademark office still has to review the specimen. If it's all good, then you get the registration. 5th and 6th year, file a Section 8 and Section 15 statement of incontestability if it applies to you. Before the 10th year, make sure you file the renewal, okay? And so this is the 1B timeline, intent to use. If you haven't launched yet, you can still apply for a trademark, lock your place in line, make sure your competitors don't get it, and get protected once you are launched. All right, this is Dan. Hope this is helpful. Again, you have more questions, pick up my book, mytmbook.com. Just pay for shipping. I'll send that to you, and I'll talk to you soon.